Hello, students. Welcome to this lecture on fundamental rights. Today's lecture will focus on understanding the fundamental rights mentioned in Part 3 of Indian Constitution, covering Articles 12 to 35. These rights are considered the foundation of Indian democracy and are described as the Magna Carta of India. This session begins with an overview of the concept of fundamental rights, their importance, and their role in ensuring equality, liberty, and justice. The agenda includes a detailed discussion on each category of fundamental rights, such as the right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and the right to constitutional remedies. We will also explore the concept of reasonable restrictions, the idea of justiciability, and the suspension of the rights during a national emergency. The lecture will highlight how certain rights are available to citizens only, while others extend to all persons, including foreigners. Another important part of this uh, discussion will be understanding the difference between fundamental rights and ordinary legal rights and how the Constitution provides remedies for their violation. Towards the end, we will look at relevant provisions like Article 13, which declares that laws inconsistent with fundamental rights are void, and Article 32, which empowers courts to issue writs. Finally, we will conclude by reflecting on the importance of these rights in protecting individual freedoms and maintaining the balance between the state and citizens in a democratic system. Fundamental rights are enshrined in Part 3 of the Indian Constitution, spanning Articles 12 to 35. They form the cornerstone of democratic governance in India. The Constitution describes these rights as the Magna Carta of India, referring to the historic Charter of Rights issued by King John of England in 1215, which marked the beginning of constitutional protection for citizens. Similarly, India's fundamental rights safeguard individuals against arbitrary actions by the state. These rights ensure equality, freedom, and dignity, which are essential for personal and social development. The Constitution originally included seven fundamental rights, but the right to property was later removed by the 44th Amendment Act of 1978, making it a legal right under Article 300A in Part 12. The remaining six rights protect citizens in various aspects of life, such as equality before law, freedom of speech, protection from exploitation, religious liberty, and access to education. These rights are enforceable by courts, meaning individuals can seek protection of their rights if they are violated. The Supreme Court under Article 32 and High Courts under Article 226 have the power to issue writs to enforce them. Fundamental rights are not absolute, they are subject to reasonable restrictions imposed by the state to maintain order, morality, and social good or public welfare. Overall, these rights uphold the democratic spirit of India by ensuring that every person enjoys certain essential freedoms while remaining under the framework of law and justice. The fundamental rights hold immense importance as they form the backbone of India's democratic system. They are essential for ensuring individual liberty, equality, and justice. These rights protect individuals from any arbitrary or unjust actions of the state. By guaranteeing equality before the law and equal protection of laws, they ensure that every person, regardless of religion, caste, gender, or region, enjoy fair treatment. They also promote the development of an individual's personality by providing freedoms such as expression, association, and movement. Another crucial aspect or is their justiciability, meaning that if any fundamental right is violated, the affected person can directly approach the Supreme Court under Article 32 or a High Court under Article 226. The courts have the authority to issue various writs like habeas corpus, mandamus, prohibition, certiorari, and quo warranto to enforce these rights. The significance of these rights also lies in their constitutional protection. They cannot be taken away or curtailed by ordinary law, but only through a constitutional amendment. However, they are not absolute. The state can impose reasonable restrictions to protect sovereignty, public order, morality, and the rights of others. During a national emergency, some rights can be suspended except for Articles 20 and 21. These safeguards ensure that freedom is balanced with responsibility. In essence, fundamental rights are not just legal guarantees but also moral commitments that preserve the dignity of every individual and strengthen the unity and integrity of India as a democratic republic. The Constitution of India classifies fundamental rights into six broad categories. These categories cover different dimensions of human freedom and equality. The first is the right to equality, which includes Articles 14 to 18, ensuring equality before the law, prohibition of discrimination, equal opportunity in public employment, and abolition of untouchability and titles. The second is the right to freedom covered under Articles 19 to 22, guaranteeing freedom of speech and expression, assembly, association, movement, residence, profession, and protection in cases of conviction and detention. The third is the right against exploitation under Article 23 and 24, prohibiting human trafficking, forced labor, and child employment in hazardous work. The fourth is the right to freedom of religion under Articles 25 to 28, ensuring freedom of conscience and the right to manage religious affairs without state interference. The fifth is the cultural and educational rights under Articles 29 and 30, safeguarding the interests of minorities by allowing them to preserve their culture and establish educational institutions. The final is the right to constitutional remedies under Article 32, which empowers the citizens to approach the Supreme Court or for protection of their rights. Originally, there was also the right to property under Article 31, which was later removed by the 44th Amendment. This classification shows that the Constitution aims to protect every aspect of human dignity, social, political, religious, and cultural, making fundamental rights essential for the holistic development of citizens and the stability of Indian democracy. When the Constitution of India came into force in 1950, it contained seven fundamental rights, including a right to property under Article 31. That this right provided protection against arbitrary acquisition of private property by the state. However, it often came into conflict with the government's policies of land reforms, social justice, and developing infrastructure, including roads, railways, and dams. To resolve these conflicts, the 44th Amendment Act of 1978 deleted the right to property from the list of fundamental rights. It was instead made a legal right under Article 300A in Part 12 of the Constitution. This change allowed state greater flexibility to implement policies for equitable distribution of resources while still providing individuals with legal protection for their property. Apart from this, the historical evolution of fundamental rights in India was influenced by various global and national experiences, such as the American Bill of Rights and the British Magna Carta, which emphasize individual freedoms. The Constituent Assembly debated extensively to ensure a balance between individual liberty and the power of the state. Over time, judicial interpretations have expanded the scope of these rights. For example, the Supreme Court in the Keshwanand Bharti case of 1973 held that even a constitutional amendment could be challenged if it destroyed the basic structure of the constitution, which includes fundamental rights, or under article or in the Menaka Gandhi case in 1978, the scope of article 21 was expanded to include article 14 and article uh, 19 as well. Thus, the historical development of these rights reflect India's commitment to democracy, justice, and human dignity while maintaining flexibility for social and economic transformation. Article 13 of the Indian Constitution plays a crucial role in protecting fundamental rights by declaring that all laws inconsistent with or in derogation of these rights shall be void. This means that no law, whether made before or after the commencement of the Constitution, can violate or reduce the scope of fundamental rights. It also states that the term law includes ordinances, rules, regulations, notifications, and customs having the force of law. Therefore, not only acts of parliament but also executive orders and administrative actions can be challenged if they violate fundamental rights. Under this article, the Supreme Court and High Courts have the power of judicial review, meaning they can strike down any law that is unconstitutional or encroaches or violates the fundamental rights. However, a constitutional amendment cannot be challenged as a law under Article 13(2). Yet, in the landmark Keshwanand Bharti case of 1973, the Supreme Court ruled that even a constitutional amendment can be invalidated if it damages the basic structure of the Constitution, which includes fundamental rights. This judgment ensures that Parliament's power to amend the Constitution is not unlimited. Article 13 thus provides a legal shield to citizens, ensuring that their rights remain protected from both legislative and executive excesses. It also establishes the principle that constitution is supreme and that all organs of the government must act within its boundaries to maintain the democratic framework and safeguard individual freedoms. The concept of writ jurisdiction is one of the strongest safeguards for enforcing fundamental rights. The Constitution empowers the Supreme Court under Article 32 and the High Courts under Article 226 to issue writs for the protection of rights. A writ is a formal legal order issued by a court commanding an authority to perform or stop performing a specific act. There are five main types of writs. The first is habeas corpus, which means to have the body. It is issued to produce a person who is illegally detained before the court. The second is mandamus, which directs a public official or authority to perform a duty they are legally bound to do. The third is prohibition, issued to prevent a lower court or tribunal from exceeding its jurisdiction. The fourth is certiorari, which allows a higher court to transfer a case from a law court or to quash its decision if it acted beyond its power. The fifth is quo warranto, which means which questions the legality of a person's claim to hold a public office. These writs ensure that the rule of law is maintained and that no authority acts beyond its legal powers. Dr. B.R. Ambedkar described Article 32 as the heart and soul of the Constitution because it provides a direct remedy for the enforcement of fundamental rights. The existence of rich jurisdiction makes the rights truly meaningful and ensures that justice is accessible to every individual. The fundamental rights in the Indian Constitution possess several important features that make them unique and of course significant. First, they are protected and guaranteed by the Constitution itself, which means that they cannot be taken away by ordinary legislation. This makes them stronger than ordinary legal rights. Some of these rights are available only to citizens, while others extends to all persons, including foreigners and legal entities like corporations. However, these rights are not absolute. They are qualified and subject to reasonable restrictions imposed by the state for reasons such as public order, morality, or national security. The parliament can amend or even curtail them, but only through a constitutional amendment and not by an ordinary law. The rights are also justiciable, meaning that individuals can move to the courts for their enforcement if they are violated. In such cases, the Supreme Court and High Courts can issue writs to protect the rights of citizens. Another important feature is that during a national emergency, certain rights can be suspended. However, Article 20 and 21 cannot be suspended even in an emergency, ensuring that the rights to life and liberty remain protected under Article. They remain protected even in cases of emergency. Article 19 rights can only be suspended in cases of war or external aggression and not during internal rebellion. Additionally, the application of fundamental rights can be restricted for members of the armed forces, police, and intelligence agencies to maintain discipline. These features reflect the careful balance between individual freedom and the collective interest uh, of the nation. The right to equality forms the foundation of India's democratic and legal structures. It is contained in Article 14 to 18 of the Constitution and ensures equal treatment and equal protections under the law. This right eliminates any form of discrimination and promotes the idea that every individual is equal before the law. Article 14 establishes that the state shall not deny to any person equality before law or the equal protection of laws within India. Article 15 prohibits discrimination on grounds of religion, race, caste, sex, or place of birth. It also allows the state to make special provisions for women, children, and socially or educationally backward classes, including scheduled castes and scheduled tribes. Article 16 provides equality of opportunity in matters of public employment, ensuring that no one is denied employment or office under the state on discriminatory grounds. It also allows a reservation for backward classes and minorities who are not adequately represented in public services. Article 17 abolishes untouchability and forbids its practice in any form, making it a punishable offense. However, surprisingly, the term untouchability is not defined anywhere except that it's a historical practice. Article 18 abolishes titles except for military and academic distinctions and prevents both the state and citizens from accepting titles from foreign states. Together, these articles remove social inequalities, promote inclusiveness, and guarantee fairness in social and political life. The right to equality not only establishes the legal foundations for democracy, but also upholds the principle of justice by ensuring that all citizens are treated equally in the eyes of law. Article 14 of the Indian Constitution is the cornerstone of the right to equality. It declares that a state shall not deny to any person equality before law or the equal protection of laws within the territory of India. The phrase equality before law means that every individual, regardless of social, economic, or political status, is subject to the same laws and equal justice. It is based on the concept of rule of law, which implies that no person uh, is above the law and that law governs all actions. Equal protection of laws means that individual in similar circumstances must be treated equally by the legal system. However, this does not mean that the same law applies identically to all situations. The state can make classifications if they are reasonable and based on intelligible differentia and have a rational connection to the objective sought to be achieved. This ensures fairness while allowing flexibility in governance. For instance, special laws for women, children, or weaker sections do not violate Article 14 because they aim to promote equality in real terms. That means the state is given the power to make arrangements for protective discrimination or affirmative actions. The article applies not only to citizens but to all persons within Indian territory, including foreigners and legal persons. It acts as a shield against arbitrary it acts as a shield against arbitrary actions by the government and its agencies. Article 14, therefore, forms the foundation for all other fundamental rights and ensures that equality remains the guiding principle of governance and justice in India. Article 15 strengthens the idea of equality by prohibiting discrimination on specific grounds. It ensures that no citizen is discriminated against on the basis of religion, race, caste, sex, or place of birth. This article applies to various spheres of public life, such as access to shops, restaurants, hotels, public entertainment, and the use of public places like wells, tanks, and roads funded or maintained by the state. The article also contains several clauses that allow the state to take positive steps towards achieving equality. Clause 3 empowers the state to make special provisions for women and children. This ensures their protection and welfare. Clause 4 allows the state to make special provisions for the advancement of socially and educationally backward classes, scheduled castes, and scheduled tribes. Clause 5, added later, extends these provisions to educational institutions, including private ones, except minority institutions under Article 30. This ensures that disadvantaged groups have better access to education. Article 15 promotes both formal and substantive equality, meaning it not only forbids discrimination but also allows affirmative action to uplift underprivileged sections. It reflects India's commitment to social justice and inclusive growth. The article prevents social exclusion and ensures that no individual or group is denied access to opportunities and facilities available to the public. By promoting equality in everyday life and protecting marginalized communities, Article 15 plays a key role in building a society based on fairness, tolerance, and dignity for all citizens. Article 16 of the Constitution provides equality of opportunity in matters related to public employment. It ensures that no citizen is discriminated against in employment or appointment to any office under the state on grounds of religion, race, caste, sex, descent, place of birth, or residence. The article aims to create fairness in government jobs and ensure that every qualified individual has equal access to employment opportunities. However, the article allows certain exceptions to achieve real equality. Clause 3 empowers Parliament to make laws requiring residence qualifications for specific jobs within a state or union territory. Clause 4 allows the state to provide reservation of appointments or posts for backward classes that are not adequately represented in public services. Clause 4A, inserted later, extends reservations to promotions for scheduled castes and scheduled tribes, including consequential seniority. Clause 4b permits carrying forward unfilled reserve vacancies to the following year without affecting the 50% ceiling on total reservations. Clause 5 ensures that laws can require religious qualifications for officers in religious or denominational institutions. This article balances the idea of merit with social justice, ensuring that historical inequalities are addressed uh, through special measures. Article 16 does not merely guarantee formal equality, it strives for equality of results by recognizing that disadvantaged groups need support to compete on equal footing. This principle of equality in employment has helped in promoting diversity and inclusiveness within public institutions, thereby contributing to the broader goal of social justice enumerated in the preamble of our Constitution. Article 17 of the Constitution abolishes the practice of untouchability in all its forms. It states clearly that untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising from untouchability is declared an offense punishable by law. This article is absolute and unconditional, leaving no room for any exception or justification. The objective is to eliminate one of the most inhumane social practices that existed in Indian society for centuries. It ensures equality and human dignity for all citizens, especially those who suffered from the caste based discrimination. The protection under Article 17 applies not only against state actions but also against private acts of discrimination. The to enforce this provision, Parliament enacted the Untouchability Offences Act 1955, later renamed the Protection of Civil Rights Act 1976. This law provides punishment for any act of untouchability and empowers authorities to ensure its eradication. Article 17 is a moral and social commitment of the Constitution to establish a casteless society. It upholds the principles of equality and fraternity and ensures that no person is denied access to public places, services, or opportunities on the basis of caste. By making the practice of untouchability a punishable crime, the Constitution reinforces the dignity of the individual. This article, along with Articles 14, 15, and 16, forms a strong foundation for social justice in India. It marks a major step in transforming India from a society divided by caste into one guided by equality, human rights, and constitutional morality. Thank you.